In the state of Georgia, parenting time is allocated based on what's in the child's best interest. You should assume from the get-go that a judge thinks that it's in a child's best interest to spend as much time as possible with both parents. Judges want both parents to be actively involved in their children's life. However, different judges have different viewpoints as to what's in the child's best interest. Some judges like joint physical custody. They want to send the child to mom's house 1 week and dad's house the next week, or mom's house 3 days and dad's house 2 days, and then mom's house 2 days and dad's house 3 days. These children are living out of a suitcase. That's not always the best way for the children, in my opinion. But if that's what the parties want to do and they think it'll work for their children, I have no problem in pursuing that. However, what we see most often in the state of Georgia is one parent having custody during the week while the children are going to school, and the other parent having visitation every other weekend, usually from Friday when they get out of school or a particular time, so 6 o'clock, until the following Sunday, let's say 6 o'clock, or returning the children to school on Monday morning. Then the non-custodial parent quite often will get a weekday visit, say a Wednesday. Sometimes that visit is simply to pick the children up, take them to dinner, spend some time with them, and take them back home. Sometimes it's an overnight visit if the parent can get them to school the next morning. It all depends on the circumstances of the parties and how close they're going to live together and where the children go to school, what works best for those particular children. Holidays are generally split equally between the parents with alternating holidays. You alternate years in regard to Christmas and Thanksgiving. Father's Day usually goes to dad, Mother's Day goes to mom. There's a lot of different ways this can be sculpted based upon the time each parent has available and the needs of the children. Quite often I have people call me because the non-custodial parent or the custodial parent has violated the court's order in regard to parenting time. This can be very difficult. If a parent that does not have custody does not return the child when they're supposed to, you can file an action for contempt and ask the court to find them in willful contempt for violating the court's order. But you have to show that you have made reasonable efforts to resolve the matter. The court doesn't want to be bogged down with minor arguments over 30 minutes. If it's a pattern of one parent violating the order over and over and over again, then you can file a contempt and the court will see that as a willful contempt and place restrictions in regard to the visitation. They can even modify the visitation, or they can even incarcerate someone. I have had cases where a parent took the children and just didn't return them, keeping them for weeks at a time. In those cases, you can file an action for contempt, but you can also go to authorities and file criminal charges and have someone arrested for interference with custody. That's the extreme. Those are rare. There's all sorts of ways of getting relief in regard to someone violating the order as far as visitation is concerned. But the solution is not to try to take the matter into your own hands and institute violence. Sometimes, if they haven't returned the children, you can actually ask the police to help you, and they will go with you to the non-custodial parent's house and secure the children for you. Sometimes you get there, and the police say, "Oh, this is a civil matter, we're not going to get involved." Different police officers interpret it in different ways. As children grow older, sometimes the circumstances change, and it's necessary to modify the custody arrangements or the visitation arrangements. Sometimes the visitation has been scheduled based upon them being very young, and their needs change. In order to modify visitation in which the parents cannot agree on how they want to change things, you have to file an action for modification, and you have to show a change of circumstances since the last order. You can then go before the court, and the court can decide what's in the children's best interest based upon the facts that currently exist. If the parties agree that a change is necessary, they can reach an agreement themselves, have an attorney draw up that agreement, submit a modification, submit a consent order. The judge will look at it and quite often simply sign it without ever having a hearing. Or the judge may have a hearing in which he brings the parties in, discusses the matter with them, and answers any questions the judge may have, and then either signs the consent order or denies it. But the best way to do it is by consent if the parties can agree. If the parties can't agree, though, litigation is the only real solution. The parties cannot change the court's order on their own. They can vary from it, but if someone violates that variation, they are not in contempt, so you can't enforce any side agreements that the parties make. You can only enforce the court's order that's currently in effect. Sometimes parents live a long distance from each other, or one parent moves a long distance from the other. These are difficult situations for visitation. If every other weekend is not a workable arrangement, if the parties live too far apart, it's too much of a burden not only on the parties but upon the children, then the court will often give the non-custodial parent more time during the time in which the children are not in school. They will give the non-custodial parent more holidays, more time in the summer, maybe every spring break, whatever will work for the children, and allow them to visit the non-custodial parent as much as possible. If you have any questions about custody and or modification of custody, Danielson Taylor will be glad to help you. Please give us a call.